Jimmy, J as in jam, I as in igloo, M as in money, M as in multi, and Y as in young. Middle name Carlton. C is in currency, A is in Atlanta, R is in rich, L is in long, T is in Tommy, O is in options, N is in Nancy. The last name is Winfrey, W is in win, I is in incomplete, N is in Nancy, F is in free, R is in royalty, E is in entertainment, and Y is in young. Jimmy Carlton.
That was entertaining.
That was creative.
Hello, everybody. Welcome to It Was an Amazing Time, Episode 3. We'll be discussing Jimmy Winfrey and his vacated conviction today. But first, I want to show you the clip that we will be referencing. And so we're going to jump right into that.
We were arguing that it was a controversial day because from our vantage point, the state was trying to suggest that Mr. Winfrey took a plea because of promises of a car or different things. But Mr. Steele at the time was rightfully pointing out that that plea was not, the Supreme Court later found that that plea was not voluntarily given.
Right, didn't that come into evidence then?
No, we were not allowed to get into that at all.
Yes, the
fact that it had been reversed and that he then entered an Alford plea instead of a guilty plea, right? That came in. That information came in, right?
The information that he had to take the plea a second time came in. I don't think the reasoning came in, but the fact that he had to take the plea. So I want to be clear. I don't know if the underlying reason came in, but the fact that he had to take another plea about a month or so later did come in.
Which that didn't help a lot for us because we wanted to get into the reasoning. But the bottom line is the plea, whether it was voluntary or involuntary at this point, it's still statements by Jimmy Winfrey, and he never took the stand.
Okay, so I'm not going to get into every aspect of that because there's a lot to unpack there, but I thought that we would start with the Supreme Court opinion that Mr. Shart references, which I have right here. It is, as you'll see, Jimmy Winfrey versus the state. He actually lost at the appellate court level, which is why the names are in that order. But here we go. We have one of my favorite footnotes of all time, just right off the bat. Appellant Jimmy Carlton Winfrey pled guilty to 6 counts of violating Georgia's Street Gang Terrorism and Prevention Act in connection with a drive-by shooting of rapper Lil Wayne's tour bus on Interstate 75. Footnote 1 reads, also known as Lil Weezy, Lil Weasel, Lil Full Clip, Young Weezy, Weezy F Baby, Weezy F Crazy, Weezy Fizzy, Mr. Coach Carter, and Mr. Shoot 'em Down. His given name is Dwayne Michael Carter, Jr. Winfrey now appeals, asserting the trial judge improperly participated in plea negotiations in violation of Uniform Superior Court Rule 33.5a, and that his plea was involuntary on the basis of that participation. We agree, and we therefore reverse Winfrey's convictions. Section 1. Winfrey entered his plea during a pretrial hearing where the status of his plea negotiations was put into the record. The prosecutor advised that the state had made 3 offers, each of which Winfrey had rejected, and that no additional offers were anticipated. Defense counsel explained that he had discussed the offers with Winfrey ad nauseum, but Winfrey was hesitant to enter a plea because of the effect Gang Act or RICO convictions might have had on his parole eligibility, and therefore he was prepared to proceed with his pending motions. This is where we get into trouble. The trial judge then stated in part, this opportunity is going away. Go to trial and you get convicted. There's not going to be any of me being concerned about when you parole out. I will not be concerned about when you parole out. I will not be able to impact what count. Only a jury can impact what count you get convicted on or don't get convicted on. So that's for your team to figure out. Whatever they say you're guilty of, I'm going to sentence you, and I'm not going to worry about when you get out of jail because it's not my concern. My concern is you went to trial, you didn't take any responsibility for what you did or did not do. It was proved if you get convicted of what you did do. I'll take that as truth because a jury said so. And I would also take into account that you didn't take responsibility for what a jury says you did. And I won't worry about your parole eligibility. And if you want to look around and see what happens to people in gangs in Cobb County, Georgia, you can look at what happened last week to the guy who went to trial and got convicted and pulled, 50 years Prosecutors: 100 to serve 50, Judge. There you go. The guys tried him. So I'm not judging them. That's what she did. I'm a whole different person, and you're sitting over in jail listening to everybody shoot their mouths off about this judge and that judge and the other judge. We all have reputations. My reputation is not that I'm an easy judge. I know it, and you know it. The whole community knows it. So if that's what you want to go up against, be my guest. You've got an offer. It's about ready to evaporate. You're not coming back to there unless you convince a jury of people from Cobb County, Georgia, you didn't do most of this. There's such a thing as winning a battle and losing a war. If you think you're so smart and you've got it all figured out, you go to trial. Let's say you get acquitted on, how many counts are there? 27? So let's say you get acquitted on 10 and convicted of 17. You add it all up, it's still a mess of time, and I don't care when you get paroled. It's not my job, it's not my function. My job is public safety, and my job is constitutionally a correct trial for everybody, which I will do. Once that's done, whatever they say you deal with, I'm going to worry about public safety. So y'all might want to talk a little bit more, but otherwise, we're going to do motions in about 10 minutes. Now, I want to unpack one little thing in here. Where are we? Right here. Let's say you get acquitted on 10 and convicted of 17. That directly contradicts this part right here. My concern is you went to trial, you didn't take any responsibility for what you did or did not do. I don't know why anyone would take responsibility for what they did not do, but that is what she's saying. Because if you go to trial because you only did 17 of the 27 things and you didn't do 10 of them, that doesn't mean you're not willing to take responsibility. That just means that you couldn't come to an agreement with the prosecution, who is unwilling to acknowledge the fact that you didn't do 10 of the 27 things. So the judge is completely off the mark and objectively wrong on that point. But let's continue on, because the Supreme Court is displeased. When the proceeding reconvened approximately 1 hour and 20 minutes later, Winfrey had agreed to what his attorneys have consistently characterized as the state's previous plea offer, and the trial court accepted the plea after thoroughly questioning Winfrey about the voluntariness of his plea and providing an extensive explanation of his rights and the consequences of entering a plea. Winfrey was sentenced to 10 years to serve and a consecutive 10 years on probation. Winfrey filed a timely notice of appeal contending that his plea was involuntary because the trial judge improperly participated in plea negotiations in violation of USCR, the Superior Court Rule 33.5. Let's see the footnote here. It is apparent from the record and briefing that there may be a continuing, albeit unrecognized, disagreement between Winfrey and the state regarding the time to serve aspect of the last offer preceding the colloquy between Winfrey and the trial court, and we have identified nothing in the record that definitively resolves the question of whether the time to serve is 10 or 20 years. That is a problem. It may well be that, considering all the circumstances in a particular case, substantial improvement in a plea offer following improper participation from the trial court could demonstrate that the defendant's choice to accept the plea was not an involuntary one. We simply do not conclude that this is one of those cases. On appeal, the Court of Appeals first considered its own jurisdiction to decide the case and correctly concluded in the face of a challenge from the state that a direct appeal is a prescribed way to challenge the guilty plea. The court went on to explain that our appellate courts have made it equally plain that under these circumstances our review is limited to only those claims that can be resolved by facts appearing in the record, and that this case met that standard. Turning to the merits, the Court of Appeals concluded that the trial judge did not improperly interject herself into the negotiation process, but added that it did not condone the trial court's comments, which appear to violate the spirit of 33.5. Nor did the trial court's comments render Winfrey's pleas involuntary, according to the Court of Appeals, because the trial judge never explicitly told Winfrey that he would be facing a longer sentence if he rejected the state's offer and went to trial, even though she strongly suggested that result. We granted cert, posing a single question to the parties: did the trial court impermissibly participate in Winfrey's plea negotiations? We conclude that the trial court did participate in Winfrey's plea discussions in violation of 33.5a, in spite of the fact that many of these court's comments were implicit rather than explicit in their meaning. We also conclude that the level of the court's participation was so significant that it rendered Winfrey's guilty plea involuntary. Continue on to Section 2. The trial judge should not participate in plea discussions. In addition to the error inherent in a Rule 33.5 violation, judicial participation in plea negotiations is prohibited as a constitutional matter when it is so great as to render a guilty plea involuntary. The cases cited indicate that in some cases a trial judge may violate Rule 33.5 without rendering a plea constitutionally involuntary. So it's essentially two tiers. One, does the judge participate, which can be improper, but then above that is the participation so significant and substantial or of a nature or character. So two different things, but certainly related. This conclusion is consistent with our treatment of other rule violations. So giving examples. Whether the trial judge violated Rule 33.5 therefore will not always settle cases like this where the voluntariness of defendant's plea is the dispositive constitutional issue. Accordingly, we must consider not only whether the trial court impermissibly participated, but also whether that participation was so significant that it led to an involuntary plea. Okay. Several factors have been consistent in this court's involuntary plea cases involving trial court participation in plea discussions. First, there has been evidence that the trial court threatened the defendant that he would receive a stronger sentence if he were convicted after trial. Here, we agree with the Court of Appeals that although the trial court never explicitly told Winfrey that he would be facing a longer sentence if he rejected the state's offer and went to trial, the court strongly suggested that result. We disagree, however, that because the trial court's strong suggestion of a harsher sentence was not explicitly stated, the judge did not improperly interject herself into the negotiation process. So the Court of Appeals apparently drew a line between implicit and explicit threats, and the Supreme Court does not seem to be on board with that particular distinction. Let us be plain. If a trial judge communicates, either explicitly or implicitly, to a criminal defendant that his sentence will be harsher if he rejects a plea deal and is found guilty at trial, then 33.5 has been violated and the plea may be found involuntary. In other words, comments by a trial judge that reinforce the unmistakable reality that a defendant who rejects a plea offer and instead opts to go to trial will likely face a greater sentence are impermissible. Several Court of Appeals decisions also demonstrate the trial court should not communicate to defendants that they had better accept plea offers because convictions after trial would, not could, result in harsher sentences. In McCraney, for example, when the defendant asked the court what sentence would be imposed if he went to trial, the judge responded, "Why don't you try it and let's see?" Then shortly afterward, the judge said, "Why don't I make it life?" and later stated, "I'll be glad for you to go to trial because I promise you I'll be your judge." The Court of Appeals correctly found that the trial court's participation in plea discussions was so great as to render the defendant's plea involuntary and reversed the denial of his motion for an out-of-time appeal. Similarly, in Gibson, the Court of Appeals reversed the Superior Court's denial of the defendant's motion to withdraw his guilty plea because, although the trial court appropriately informed the defendant of the maximum sentence, it went further by advising the defendant that the court would not give him the same sentence considerations in the event that he opted to proceed to trial rather than accept the proposed plea. In Hayes, on the other hand, we found no error in the trial court's statement that if the defendant rejected the plea offer, you're going to have a trial and you are facing 20 years and you would serve every day of it if you are found guilty. And that was the sentence imposed by the court. Instead, we found the trial court's careful and repeated use of conditional language was appropriate where the trial court merely advised the defendant of the mandatory sentence he was facing as a recidivist were he convicted at trial. The trial court's explanation of the potential maximum sentence was carefully expressed in conditional language, avoiding any positive statement of what sentence might be imposed after a trial. So the trial court merely informed the defendant of the potential maximum sentence he was facing and the potential consequences of his decision without communicating whether that sentence would likely be imposed. Similarly, in the interest of SF, It also found that the violation did not render the juvenile defendant's admission involuntary because in informing the juvenile that he would face the maximum sentence if he rejected the plea offer, the judge did not make any threats of a longer term of confinement if the juvenile chose to go to trial. The key distinction, then, is whether the trial judge threatens that a sentence will be harsher after conviction if a plea offer is rejected, or advises that the sentence may be harsher. The former should not occur, and it is of little significance whether the trial court accomplishes that communication with explicit or implicit language. This holding comports with Georgia courts' longstanding and recently reiterated recognition of the difference between telling a defendant that he could be sentenced to up to the maximum statutory sentence and telling a defendant that he would be sentenced to the statutory maximum if he forgoes a plea and is convicted at trial. The comments in this case crossed the line. The trial court made repeated statements that referenced the judge's own proclivity to sentence harshly, along with other statements strongly implying that if Winfrey were found guilty by a jury, his sentence would be, not could be, so not conditional, harsher than that recommended in the plea offer. Specifically, the court told Winfrey, if you want to look around and see what happens to people in gangs in Cobb County, Georgia, you can look at what happened last week to the guy who went to trial and got convicted and pulled 100 to serve 50. There you go. These guys tried him. The court went on to imply that her reputation would mean an even harsher sentence. I'm a whole different person. We all have reputations. My reputation is not that I'm an easy judge. I know it. You know it. The whole community knows it. These comments may not have explicitly stated that Winfrey would receive a harsher sentence if convicted after trial, but this monologue was far more than the mere explanation of the potential maximum sentence, carefully expressed in conditional language that we approved in Hayes. The implication was unmistakable. If Winfrey rejected the plea offer and the jury found him guilty at trial, he would be sentenced more harshly. And even those comments were not enough. Instead, the trial court chose to re-emphasize the risks that Winfrey would take by going to trial, so if that's what you want to go up against, be my guest. Let's see, footnote 4. As this suggests, a judge cannot immunize impermissible threats to sentence a defendant more harshly simply by couching the threats in conditional language. This brings us to another point. Expression by a judge of a personal interest in giving the defendant a heavy sentence is another factor that Georgia courts have looked to in analyzing involuntary plea cases like this one. In Pride, the trial court informed the defendant that if he rejected the plea offer and was found guilty after a jury trial, then the court would stack the sentences and give him the maximum. But the court went further by stating, I am happy to try him, and he's going to get a lot more. I would really rather try him, frankly, so I can give him what I would really like to give him. We found that the court's repeated statements that it would impose a longer sentence if the defendant went to trial, including statements that the court preferred that he went to trial so that a harsher sentence could be imposed, constituted judicial participation so significant that it rendered the defendant's plea involuntary. The comments by the trial court in this case were similar in nature to those found inappropriate in Pride, in that they intimated a desire to sentence the defendant. And they were shortly followed by the additional statement, if you think you're so smart and you've got it all figured out, you go to trial. While not quite as direct as the court's comments in Pride, the colloquy in this case strongly suggested that the court would hold it against the defendant if he went to trial. Indeed, the judge's statement that if Winfrey wanted to go up against her reputation, then be my guest, and that he should go to trial if he thought he had it all figured out, were very similar to the McCraney judge's invitation to the defendant, why don't you try it and let's see. Additionally, the trial court knew that parole was a key decision point for Winfrey and specifically told him that if she were called upon to sentence him after trial, I don't care when you get paroled. Also remarkable, a little extra here at the end. Also remarkable was the trial court's statement to Winfrey that he would have to convince a jury of people from Cobb County, Georgia, he didn't do most of this, an explanation that shifted the burden of proof from the state to Winfrey. But of course, the state bears the burden of proving a defendant's guilt beyond a reasonable doubt, and the burden never shifts to a criminal defendant to present evidence of or to prove his innocence. It is entirely reasonable to believe that this burden discussion further impressed upon Winfrey that he should plead guilty because he would not be treated fairly at trial. Taken in their entirety then, the trial court's repeated comments communicated to Winfrey, albeit implicitly, that if he rejected the plea offer and was found guilty by a jury, then he would, not merely may or could, receive a harsher sentence. We must conclude, in light of these comments, that Winfrey's guilty plea was involuntary. Judgment reversed. There are two dissents. They agree that the comments were inappropriate and a violation of 33.5, but they didn't believe that it rose all the way to the level of an involuntary plea, causing an involuntary plea. But all justices unanimously agreed that the trial court's comments were inappropriate. So that is the background of this case. That is why Jimmy Winfrey's conviction was reversed and why it was found to be coerced. And that is what Max Shart was discussing and Brian Steele before him were discussing with respect to the reversal of the guilty plea. And remember, the state didn't want any of this information to come in. All they wanted was the fact that Mr. Winfrey had to plead twice. They didn't want this opinion coming in. They didn't want the jury to know that the first conviction had been reversed. Even though I think the Supreme Court's sentiments are pretty unequivocal here, they are explicit rather than implicit. They're quite strong in their condemnation of the trial court's behavior and comments in this case. So I think that this is a pretty remarkable decision just because of how, like I said, how explicit it states its sentiments and voices its opinion. So that is going to be it for episode 3. I hope you enjoyed it, and we'll have episode 4 along shortly. Thanks for watching.